Well, hello, and welcome to this episode of Unfair Advantage, where we explore strategies, insights, and methodologies to give you an unfair advantage. As you know, I'm Mona Hilton, CEO of Advantage Anywhere, and we're always proud to bring you topics and guests that will stretch your mind and grow your business. And of course, if you've missed any of the amazing episodes of Unfair Advantage in the past, or maybe you just want to binge watch on topics that will improve your business and life, check out the Unfair Advantage recordings at www.advantageanywhere.com/videos. And be sure to subscribe to our ever-growing YouTube channel for the very latest and information on the hottest business and leadership topics. Well, folks, today's a first for Unfair Advantage. As you know, one of my greatest joys is introducing you to thought leaders that you would otherwise never have the opportunity to get to know. And we typically talk about leadership, sales, marketing, and tech. But today, we're going to talk about the topic that is on everyone's mind. I don't care who you talk to, in what industry, at what level of leadership, everyone is talking about staffing issues. They're talking about the shortage of staff, the new predicaments with remote workers, and the changing landscape in employment as a whole. So we're going to spend some time talking about staffing and employment today. Staffing issues have gone to a whole new level in the last few months. So what do you need to know in order to make wise staffing decisions and, frankly, protect yourself and your company? And what would you give to get legal expert advice? Well, I said today was a first because today we're talking to an attorney, actually a legal expert, and not just any legal expert. Folks, we're going top shelf here. Diane Geller is a partner at Fox Rothschild, which is a 100-year-old, very well-respected, full-service legal firm with about 950 lawyers and offices coast to coast. Now, Fox Rothschild covers a full range of legal issues, from family-run businesses to multinational corporations, all centered around several core areas in corporate, employee benefits, entertainment, financial restructuring, bankruptcy, intellectual property, labor, employment, litigation, real estate, taxation, wealth planning. You get the idea. And Diane is a sought-after partner at Fox Rothschild. So you're going to want to have a pen and paper ready for today's conversation because you're about to hear from the very best. And I'm so looking forward to talking to Diane today. So welcome to the Unfair Advantage, Diane.
Thank you. I'm looking forward to having a chat with you.
Oh, what an honor it is to have you here today and to introduce you to our audience and have this conversation on staffing and employment issues from a legal perspective. Even just talking to you, I was just blown away with some of the things that you told me, and I've scribbled a ton of notes. And I know our audience is going to love it just as much. So at the end, I'm going to share with you a little bit about Diane's contact information so you can reach out to her and maybe engage her. But let's dive right in. So Diane, everyone's talking about staffing. It's such a huge issue. Everyone knows that there's not enough bodies and people are poaching employees, and I've just never seen anything like that in my lifetime. How have you seen the staffing landscape change in the last year or two?
Well, I think you really hit it on the head, Mona, because people are moving around much more than we used to see them move. And poaching is exactly right. I was just with a client yesterday who was talking about employees that were resigning because they were so in demand, that other employers were bidding for their services.
Wow.
So that is certainly happening. You also, the Great Resignation wasn't just a resignation from work, it was a resignation too to go to other employers.
Mm-hmm.
So we're seeing so much change where non-competes were strong and available. Our our present administration has been eroding them, so those protections may or may not be available. In addition, they're getting eroded on various state levels, so the ability for employees to move around is getting greater and greater. The other thing is the demands that employees are making. The demands are very different. That it isn't, whilst money is important, and certainly now with some economics pressure, money becomes more important, but money also relates to the quality of life and what employees are demanding. The ability to work from home so that people don't have to commute every day to the office.
Mm-hmm.
We're seeing that among clients, and I'm seeing that in my own firm. Some of the very in demand, for instance, legal secretaries, now part of their requirements are being able to work remotely. And that's something that, at least in law, you never saw before. So definitely the landscape is changing. The attraction of employees, and what is it that those type of employees, and when I mean type, I mean the kind of position that you're looking to fill, what are they looking for? And you really need to survey that and be responsive to what's going to make you most competitive.
Yeah, wow. These are definitely different times. And so, how have the laws or the regulations changed? Have they changed? Are they in flux? You mentioned that some of the laws are eroding. What has changed there?
Well, there's a bunch of changes that we've seen. Certainly, more and more states are going to paid sick leave. And we're watching to see if the country as a whole goes to a paid family leave act. It hasn't happened yet, but it could happen. So we're seeing that change. So employers are having to make sure that their PTO or vacation and sick policies will put them in compliance with their state and local laws. And we're seeing both that, state and local laws. We're seeing states dramatically change their laws. And the problem is, or the good part is, depending on which side of the boat you're on, is that some of these state laws are really restrictive on employers. The whole thing with biometrics. And now the EEOC has come down with a new attack on AI and how you can use AI as part of your hiring decisions. Many employers use AI to help them decide on whether an employee was a good fit, and felt confident because it was they felt it was a non-discriminatory, and the vendor would say it's non-discriminatory, but now that may not be enough based upon the newest guidance that came down from the EEOC. It's in the past with ADA, Americans with Disabilities Act, employers were very confident in saying a position had to be performed in the office and couldn't be done remotely. But guess what? For the last now couple of years, we've had the same position being filled remotely. Wow. So the question is that really an essential function of the job?
And how does that change, like employee agreements or company manuals, policies, procedures? Do employers need to reevaluate all of those things?
Well, they really do, because how are you going to deal with remote employees? You and I have talked about in the past issues relative to workers' compensation, for example. If you have a remote employee, you need to understand that they're covered by workers' compensation when they're working from home. So they trip and fall when they're on the way to get a cup of coffee. That may be a workers' comp claim that you need to cover. Other things are, do you pay taxes in the state where that remote employee is working from? In the past, you just paid taxes in the states where your employees, came into the office. Well, now not everybody's coming into the office, and, maybe they're working from a state that you didn't normally have on your agenda. So now you've got to make sure that taxes are being properly remitted for unemployment, especially. Are you an employer within the state? Do you need to be an employer in the state? Do you have workers' comp in the state? Are you covered for that employee working from home? You might also consider entering into a remote employee agreement so that if you want to make this a quasi-temporary arrangement, reserve the right to have them come back to the office. And how about managing? I know there are employers that count keystrokes so that they know that remote employee is working for the 8 hours, 7 hours, 6 hours, whatever they're supposed to be working. It's very hard to manage them. So, you almost feel a little bit like Big Brother in terms of counting keystrokes, but how else do you know the employee is truly working? And that's more so, and a big issue relative to hourly paid employees versus salary paid employees. And don't think that, okay, I'm just going to pay the person a salary and not have to worry about it, because you can't do that. Under the Fair Labor Standards Act, there's only certain people that you can pay or certain positions that you can pay a salary to and not go afoul of misclassification. So, and a non-payment of overtime. So there's lots of moving parts in having remote workers.
Yeah. And as you kind of mentioned to me earlier, when you have remote workers in different states, you've got to deal with the employment laws, minimum wage and overtime. And like you said, workers' comp and, insurance and all those other things. And, how much of that do you really have to worry about? If you go with like a PEO, is it a PEO? Do they take care of that for you? Or is that something you still need to be concerned about?
Well, going with a PEO, which is a professional employer organization, where they're technically the employer of all of the personnel, can be helpful in that, depending on what services they're going to provide you. Be careful when you're entering into those agreements, because you're still a co-employer and they're still going to say they rely on the information that you provide. So you need to find out exactly what they're going to do for you and make sure that liability, how that liability divides up.
You were actually talking to me about, I'm sorry, I didn't mean to cut you off, but you were talking to me about workers' comp as well, if you're paying them direct.
Well, if you're paying them directly, you've got to make sure that your comp policy will cover them. And there's, endorsements to your main comp policy that may work. If they're a PEO, the PEO should have workers' comp in the state. And then it's just going to be a case of classification and how you're classifying those employees. And then, of course, managing risk. If it's someone more than just sitting at a desk, typing, well, how are you managing that risk when they're going out to client site?
You'd also talked to me earlier about being an at-will employer. Would you share that a little bit more?
Sure. Almost all the states in our country recognize at-will employment, which, as I mentioned to you previously, it means that you or the employee can leave at any time with or without notice and with or without cause, provided that you can fire them, provided it's not for an illegal reason. So you still have to worry about discrimination and other claims similar to that. So even though you can decide you want to fire someone because you don't like the blouse that they're wearing today, it doesn't mean that the person's not going to bring a claim back against you, saying it really had nothing to do with my blouse. It had to do with my race, religion, national origin, gender, sexual orientation, any of the protected classes. So I think that also gets us into another topic we were going to talk about, and that is, how to deal with employees. And I think it becomes so important to have documentation. Oftentimes when I'm giving a presentation, I have a slide that just says document, document, document. And that is, while you can fire anybody for any reason, as long as it's not an illegal reason, the issue is, what documentation do you have to show that it's not an illegal reason? Have you given that person warnings? Have you sat them down and talked to them about the essential functions of the job? Have they indicated if they were having a problem doing it, and how did you respond to that? Is it an ADA accommodatable issue? All of that needs to be evaluated as part of making that firing decision. And once again, employees are so hard to find, a quick firing may not be the answer unless it's a serious issue.
Yeah, so you were talking also about counseling.
Yes, so that's where counseling becomes important. Every time you have to go out and advertise and then spend executive time interviewing and qualifying and background checking and, doing all the things that you need to do to hire a qualified, hopefully qualified, quality employee, you're spending a lot of company resources, and you can't continue to do that without it having an impact on the bottom line, because it's taking away from management time or sales time or other important business time. So if the person seems to be qualified and they're just slipping up a little bit, the answer is to engage in counseling. Can I fix this employee? Can I save this employee?
Mm-hmm.
Can I tell them what's going wrong so that they can make it right? Giving them a chance is oftentimes a good decision, and you will have saved an employee. Now, that doesn't get rid of the issue, and this is the hard part, is to make that decision. If the employee can't be saved, then you need to just end it. Don't put it off. Don't delay, because I think the term I used with you is no good deed goes unpunished.
Mm-hmm.
So even though that employee is somebody that you feel badly, their spouse got laid off, or they have a sick child, or they're sick. If it's not an ADA issue that you've got to be concerned about, you're entitled to have you're entitled to have them perform the essential functions of the job. And I think the other thing you and I chatted about was in terms of PIPs, personal improvement plans. Well,
Right.
when you're giving a personal improvement plan, don't say, I'm giving you 30 days to improve. Talk about giving up to 30 days to improve. So if the person isn't making any steps towards fulfilling the set markers that you've given them, it's time to go. You don't want to keep them for 30 days. And realize that if somebody knows they're about to get fired, they're more apt to look for a discrimination. They're more apt to trip and fall and now have a workers' comp claim, or go out on some other kind of disability. So, saving them is great, but cutting them and moving on is also important. I've had so many clients who have felt bad for an employee and delayed making that firing decision, only to get bitten by it, because when they finally did, the employee came back at them. And documentation, and let the employee know, have them sign that counseling form. It also helps that when the time comes that they're being fired, it's not a surprise to the employee. They know they weren't performing. You gave them warning. So all of that's very helpful.
Yeah, guilty as charged. I've fallen into that trap as well. I think we all have, and it's an expensive lesson. It really is.
I have one other thing, and I was telling this story yesterday to a client. If you're going to fire somebody, make sure they know they've been fired. Because I used to have I'm very serious, because I used to have a managing partner of a prior law firm I was in, who we affectionately called Papa Smurf. But the nicest man you could ever meet. And the story goes that there was an associate who wasn't performing, and he thought he fired the person. Well, this was on a Friday, and on Monday morning, that associate showed up for work as usual.
What?
Because he didn't make clear, not saying, well, this isn't working out isn't the same as saying this isn't working out, so we're going to let you go, or we're going to, terminate your employment as of today. If you don't complete the thought, that employee may just say, okay, well, it hasn't been working out, or it's not a good fit, but let me try and improve it. So make sure they know they've been terminated. And please, on separation pay, do not give separation pay without getting a release. Do not give separation pay without getting a release, because the next thing will be you'll have a charge filed against you at the EEOC, or they'll trot off to a lawyer and you'll get a lawyer's letter that you just funded by paying them a separation of pay. So get a release.
I didn't know that, Diane. That's really good advice. So when you give them separation pay, in other words, a fee like just after this is your last day, but we're going to pay you for the next month or whatever, you want a release at that point?
Yes. And the releases are slightly different if the person is under 40 or over 40. And
Really?
that has to do with a Age Discrimination and Employment Act section that has to go into an over 40 release. So make sure you're not asking your brother's cousin's uncle, who's a real estate lawyer, to help you with it. You need to get somebody who knows what they're doing.
Oh my goodness. I told you, I hope you're writing down notes, people, because this is priceless.
Okay.
I again didn't know that. Diane, I want to circle back on something else. We were talking about remote workers, and I
I
think
love this.
this is such, yeah, this is such, I know. This is not someone who works at our company, just for full disclosure, but um remote workers is such a big thing. I know that we've never considered remote employees before, and now we are actively doing it. So it's such an issue. And you were talking to me the other day about, equipment and company owned equipment versus employee owned equipment and downloading information. And what if they leave and HIPAA and all of those things? Could you kind of talk a little bit about what do you do with remote workers in regards to their assets, or your assets, I should say?
Yeah, I think that there are so many issues. Just as an observation with this picture, and then I'll move on to answer your question. You also need to set criteria for online meetings, for Zoom meetings. What is that employee showing up looking like? Are they paying attention? Have they, well, do they realize you're watching them? I think there was a commercial on television a while back when we were all going through the pandemic, where some guy wanders out of the house to get on a Zoom call with their friends, and their friends are physically sitting there, and he comes out in his underwear.
Oh my
So
gosh.
you don't want your employees showing up for business meetings in their pajamas or not dressed professionally, at least from the waist up.
Don't stand up.
That's right. But, that's important because they're still displaying and they're still representing your company. And, to answer the question that you just raised, and it's very important because you need to protect your assets, whether it's your client lists or your employee lists or your patient lists or whatever they're working on. Those are all your assets. So you want to make sure that you've protected them. When they're working on their own equipment, how have you protected your assets from them downloading it, copying it, printing it, and then going across the street and working for a competitor? So I think that's one issue relative to allowing people to, there's this concept, bring your own device to work, BYOD, and not BD. And I think you've got to be able to control your assets. You've got to be able to control what they're using and what equipment they're using. So if you're giving them and assigning them equipment, which, by the way, you should keep a record of and have them sign for the equipment that they're receiving, so that if you ever have to proceed against them to get it back, you've got proof that they've, because if you have to go after them for having stolen or converted your equipment. But more importantly, remember that much of the information there is sensitive. You mentioned HIPAA. So if they're downloading at home HIPAA information or have access to information that's protected by HIPAA, and they're putting it on their own equipment, you've got a whole other issue in terms of protecting that and your obligations. In addition, there's always the risk of where are they working? Are they sitting in the kitchen on their kitchen table working? And they're looking at HIPAA protected information or other confidential information where the next door neighbor could walk in, or the spouse can walk in, or the repairman can walk in. Any of that. And now you've got protected information that is visible to third parties that shouldn't have any visibility to it. And you're risking not only losing it, you're also risking litigation. The last issue that I want to mention is when you unfortunately get dragged into litigation and you've got to produce all of your electronic information, all the emails, all the data. Well, will you have access to it if they're using their own equipment? And then you've got to worry about, if they're using their own equipment, erasing it when they leave and having access to erase.
So is the best practice to assign them company owned equipment, have them sign off on it? and require they return it upon leaving. But even that doesn't protect against HIPAA. Like you said, a repairman can walk past and look at what's on the screen.
That's true. It does not protect against HIPAA. Some of that may be if you're now setting people up as true remote employees, that they have to have a private place in their home that they can work, that's not accessible to other people. Design in a situation where the screen will go blank if no one is using it for a certain number of minutes. All of that will help, but it is a risk.
So are these criteria that you should put, obviously talk to your attorney or talk to Diane, but are these things that should be put in the company manual that they sign off on, that they agree to these terms?
Well, some things may be able to go in a company handbook or manual, but some things may have to go in a separate document. If you're using a company manual, what I tend to do is add sections at the end for really important issues that I want them to sign off on, because certain things can't be put in the manual and be effective. For instance, in Florida, you can't put a non-compete in a manual and then seek to enforce it, because the employee has to sign it. If they don't sign off on it, then it's not enforceable. So there are things that you want to have either in a separate agreement or certainly a separate acknowledgement.
Wow. Well, that's actually a good segue to the next thing I wanted to talk to you about. Is obviously we have to hire staff. There's no way around that. So we can't just say, well, we're just going to stay with what we have and not hire anyone new. So we're always looking to hire. But what advice would you give employers when they're hiring new staff as far as background checks and what have you?
Well, background checks, you really want to do background checks. In some states like Florida, if you've done a background check, you can also escape liability for negligent hiring if somebody's going into, for instance, someone else's house and then commits a bad act. Or, if you've made an attempt, and there's very specific statutory language for many positions to do a background check, and you did, the certain things listed in the statute, you can avoid negligent hiring. But do a background check, but make sure you're in compliance with the Fair Credit Reporting Act. If you're using a third party to do that background check, really important, because that's still a hot button legal issue where there's still lawsuits being filed if you don't follow the rules, and the rules are very specific. So make sure either you're using a qualified criminal background checking company that can give you the forms that you can rely on, or speak to an attorney who understands it. Decide what you're going to do about drug testing. Are you going to drug test? Are you going to drug test for cannabinoids? That's been a big issue. Many people have given up, and some states require you no longer to test for cannabinoids.
Really?
So, you need to know what your state law is, and then you need to make a decision how important that is. In fact, in Florida, with some of the big employers, and I'm sure it is in other states, you get a discount on workers' compensation if you have a drug-free workplace, and cannabinoids are still listed as being part of that drug-free requirement. Now, that having been said, you need to talk to your comp carrier, because some of them will no longer require you to eliminate cannabinoids in order to get the discount. So you want to know that. You also, frankly, want to know whether your comp carrier in your state is going to provide insurance for cannabinoids that are issued for a workers' comp injury, because that's a new hot button in the law. And the advice that I gave you the other day, and you mentioned it earlier when we were speaking, is don't let your desperation get in the way of a good hiring decision.
Diane, say that again. I want people to hear that. That's worth its weight in gold. Say it again.
Don't let your desperation get in the way of a good hiring decision.
Yes.
Don't be so desperate that you're going to compromise the need for somebody who meets the essential functions of the job. Make sure you're trying to at least make a good fit. It's not always going to happen, but at least start out with the belief that you've got a good fit. Because when it comes time to, unfortunately, let that person go, and it's an issue over the fit, you're going to have to at least have a file of why they did not meet the essential functions of the job. And, shame on you that you hired them knowing that it wasn't going to be the right person and you were just needed a body.
And you were talking about the drug testing and cannabinoids. You layer remote workers that are working out of state on top of that, and it becomes even more complex.
You can require in, I believe, every state still that somebody does not use cannabinoids during the course of the workday. But, how embarrassing if you have an employee who gets on a Zoom call with a customer or client and they're high and they're all over the place and munching on Doritos. That's not always the case, but you want to be somewhat concerned about it. But once again, since they're remote, you need to know what the laws are of that state. You need to know the tax laws, and you need to know the employment laws that you're going to be subjected to. So those are really important.
Or you need to have an attorney with contacts in all of those states who can advise you. So that's talking about new hiring staff. And I know there's some overlap, but what advice would you give regarding existing staff? I know you told me don't cut corners, Mona.
Right. You don't want to cut corners, but in the same light, you want to be able to, two things. You want to be able to have people that are going to meet the essential functions of the job. You want to be able to, if they were good and now all of a sudden they're not good, there's something going on there. Now, you have to be careful as to your inquiries because you don't want to know too much, and too much detail. But if the person needs some assistance and they don't have to say, I want to apply for Americans with Disabilities Act accommodation. They don't have to use those particular words, just like they don't have to say, well, I want to take family medical leave if your organization is subject to it or whatever the state law is. You have to be able to read that from the conversation that you're having. And especially in an ADA situation, please, please, please make sure you engage in what's called an interactive conversation. What is it that they need? How long are they going to need it for? What are you asking for? And if they say, well, I don't really know, well, then you've got to still explore it. That issue of having that interactive conversation is so important. I mean, we've had cases where it was a retail space and the owner of this retail space was so accommodating for a really long time. They would, person needed time off, they needed part schedules, they needed whatever they needed, they gave to them. But they never had that interactive conversation. And after the person, they finally could not accommodate the person any longer, and they fired them, and the person sued under the Americans with Disabilities Act. And the court found against them because they didn't engage in the interactive conversation, even though they gave them all kinds of accommodations. Since they didn't have that conversation, we got a judge that found against them. So,
And you have to document that conversation too, I'm sure.
Oh my goodness, yes. Document, remember? Document. Please do that. Have counseling records. I just came yesterday from an interview where they were interviewing our client on the Human Rights Commission was interviewing our client who was the president of a pretty substantial company because one of his subordinates got terminated. She was claiming age discrimination. And this guy has been all over the company because they didn't have that counseling documentation. They didn't have anything showing that she knew she wasn't performing, that they told her, even though there's lots of emails of materials being returned to her to be redone or not hitting time requirements, so you got to go through the steps, even though we're an at-will employer.
So even though they had emails going back and forth, documenting means that the employee would have to sign off on that as well, right?
Yes.
Okay.
And, do I think it was it's required by law? I don't. I think, though, that remember who's doing the investigation, and it is wise.
Mm-hmm.
It is wise to do. Oh, one last thing. When you're doing going back to new offers, when you're giving an offer, please make sure you put in your offer letter that it's an at-will employment, and make sure that somebody's reviewed your offer letter, an attorney's reviewed your offer letter who knows what they're looking at, because that can make the difference from going from an at-will to being someone that you can only terminate for cause. And you don't really want to be hung up on that.
Oh, wow. So even in an at-will state, you put it in your employment offer.
Absolutely. You want to make it crystal clear. It should be all over your handbook. It should be all over that offer letter, not all over, but it needs to be in that offer letter. And it needs to be clear that your offer letter is not a contract of employment and you're not guaranteeing the person a period of time. You want to reserve the right to fire them at any time for any reason, as long as it's not an illegal reason. But understand they have the right to leave too, although many people, and let me talk about that for a minute, many people will give notice before they're going. And that's a very hard decision for employers, because you kind of like to have notice, but then is that person going to start downloading all kinds of information, and will you have
Exactly.
confidential information walking out the door? And do you really want somebody who's about to leave and go somewhere else, possibly a competitor, talking with your customers and clients and patients, etc.? So think about whether it's really worth keeping them for those 2 weeks or month.
Yeah, I've been faced with that myself, and it really depends on the individual. Diane, talk to us a little bit about undocumented aliens and I-9s and all of those kinds of things.
Well, another very hot button issue. I-9s have been in place for a very long time. In Florida last year, I think it was, we also added an immigration statute. You really need to be in compliance. You need to go back and review your I-9s to make sure they're being completed correctly. Do not dictate what the candidate or employee has to provide you with. As long as they provide you something from column A or column B and C, that's enough. You can't say, you must bring me your driver's license. You must bring me a Social Security card. You cannot specify that, because you will get nailed by the Department of Justice or INS over that. In fact, we were just fighting a case last week where the Department of Justice came into a client of ours because they would not accept the documentation that a candidate provided, because they didn't recognize it. Actually, the part that they saw didn't even have the person's name on it. And it kind of started at item number 12. And according to the local manager, he did not see anything else. He didn't see another side of it. Well, this lady trotted, now we asked her for other documentation. We told her as soon as she brought the documentation, she could start the position. And yet she trotted off to the Department of Justice and filed a charge for discrimination against someone who is legally authorized to work, but not a U.S. citizen. And, it's preposterous, because in this case, it's a restaurant who is desperate for servers. So they would have hired her they actually hired her on the spot, and they would have started her, but for the fact that they didn't recognize her documentation. And as a result, we are going through, or the client is going through, expensive hell over this person making a claim. And it's really not a reasonable claim. It was wrong. And even if it was a mistake, it was not a malicious mistake. It was not based on the person's national origin. So, but it still gets expensive. The other thing is that they wanted to see 2 years of I-9s. And I will tell you that the I-9s in this case looked awful, because the local managers, who were the ones responsible for getting it and filling out, reviewing the documentation and filling out the employer section, weren't being careful. And I'm still waiting to see if we're going to get, or the client's going to get hit with significant paperwork violations, which will be significant fines as a result. So look at your I-9s, make sure they're being properly filled out, and go through and get rid of ones that you don't still have to retain under the law. Take a look at the statute. If you don't have it, you can pull it up online, or you can call your attorney, but you want to only retain documents that you have to retain. Because if you're sitting with them, they're entitled to them, even if you could have destroyed them.
Because you never know who you're dealing with. I mean, in the example you just described, it was the company wanted to hire them, but you just never know. So you've got to think about everything and dot every I and cross every T, and a
Yeah,
lot to it.
we're seeing that. We're seeing a lot of wage and hour audits and investigations. One disgruntled employee can bring the Department of Labor knocking at your door. And then, once again, you're kind of showing them the inner sanction, and they get to interview other employees, and it becomes quite a challenging event.
Are you seeing more of these, Diane, or is this how it's always been?
Now we're seeing a lot more government intervention and a lot more government looking for fines so that they can, put money in the coffers. We've given away a lot of money over the last few years, and this is one way to get it back.
Oh my goodness. We've kind of already touched on protecting assets. Is there anything else you wanted to add to that?
Confidentiality agreements.
Okay.
Non-solicitation agreements, if they're legal in your state, non-competes, possibly if it's legal in your state and it's not going to impair you in hiring. But definitely go through the effort of getting it, confidentiality agreements at a minimum.
Okay. Good advice. Well, I think every employer on this call or listening to this recording is becoming a little anxious and scribbling a lot of notes and going, "Oh my goodness, what have I gotten myself into?" Especially the small businesses. What positive is coming out of this, Diane? What opportunities are hidden in today's staffing climate? What do you see?
Well, I see now. A lot of people returning, even though the job numbers were down this month, a lot of people returning or looking for better jobs. You need to get out there and figure out what the folks that you want to attract are looking for. Is it remote working environment? Is it more life-work balance? Is it money? Make that determination. And there are people out there that have the qualifications that you want. You just have to, if you look for them, they're there. You just have to figure out what the right avenue is and make them walk into your door, not the other two doors.
Mm-hmm. Well, and also I think just being able to recruit, maybe not everyone needs to be remote, but being able to attract people that you wouldn't otherwise have been able to attract because of the remote options. Despite all the potential pitfalls, you can get good talent from other areas.
That's true. We're much more flexible population than we've been in the past.
Well, we've talked about a lot of things, Diane. This is amazing. I'm going to listen to this at least 2 or 3 more times and scribble a lot more notes. But if there's one thing, we talked about a lot of things, but if there's one thing you want people to take away from today's conversation, is there one, maybe 2 things, Diane?
I think we already talked about them, Mona. I think that's don't let hiring despair get in the way of a good decision. Mm-hmm. Know what the law is and follow it. And of course, no good deed goes unpunished.
Mm-hmm. I think your email is going to blow up after this. I just want to thank you so much, Diane. This was, gosh, I couldn't even put a dollar figure on all the advice you just gave. And I do expect that people are going to be reaching out to you. Diane's contact information is on the screen. And Diane, thank you so much. What a wealth of information you are, and what an honor it is just to know you and have the opportunity to introduce you to our audience. And thank you so much for sharing all of your knowledge. Not all of your knowledge. We barely tipped the surface, but thank you for sharing with us, Diane. And to those of you watching today, I just want to thank you. I hope that you found this as amazing as I did. If you would like to reach out to Diane, her contact information is on the screen. You can reach her by email. You can definitely connect with her on LinkedIn. And if you need to reach out to me for any reason, my information also is on the screen. So I want to thank you all for joining us today. I encourage you to, again, subscribe to our YouTube channel so you'll be in the know with the latest information. And I look forward to seeing you guys all on the very next Unfair Advantage. Thank you, Diane. Thank you, everyone. Have a great day.
Thanks, everyone. Bye.
Bye-bye.